by the allegations. I am going to leave no stone to fight the charges and to indicate that the allegations are inaccurate and cannot be true. I have been informed that for the offences of the nature I am being charged, there may well be minimum sentences of imprisonment imposed by the court if found guilty. I maintain that I have a defense to the allegations, one being an alibi. I reiterate that I want to stand my trial and explain all circumstances which led to my arrest, insofar as I am able to do so, and to present evidence, including expert evidence, if necessary, to dispute whatever allegations the state may have against me. The prospect of standing trial does not instill any fear in me, as I believe in the courts and justice will prevail. I respectfully submit that the nature and gravity of possible punishment is overshadowed by my desire to stand trial and for the sake of my family and to clear my name. I am acutely aware of the fact that the alleged offences may impact negatively on my family. It is for this reason that I want to stand trial. I believe and submit that the court may impose stringent conditions upon me which could curtail my possibility of movement and would therefore have a binding effect and would be easily enforceable. Such conditions, in my respectful view, would not be breached. Whether there is a likelihood that if I was to be released on bail, I will attempt to influence or intimidate witnesses, as envisaged in Section 60, subsection 4C, read with Section 60, subsection 7 of Act 51 of 1977. I respectfully submit that the court has to take into account the following factors, namely, I do not know the identities of any possible witnesses who may have made statements or agreed to testify. I know of no witnesses who is able to identify me, as I have not attended any identification parade. I believe any perpetrators of any unlawful offense should be dealt with by law, and I would not seek to interfere with any witnesses, which witnesses I deny having knowledge of their identities or knowing them personally or at all. I nevertheless undertake not to communicate with, in any way, contact witnesses which the state may list and agree to abide by any conditions in this respect. I have no access to any evidential material which is to be presented at my trial, and there is absolutely no reason to fear any interference from my side. There is no evidential material that could be concealed or destroyed by me. I believe that the state has already secured any evidential material that is intended to be used at my trial. Further, I have chosen an alternate address outside the province of Gauteng, so as to prove to this honourable court that I have no intention to interfere or communicate with any of the witnesses. I will travel to each and every court appearance at my own expense or with the help of my family. Whether there is a likelihood that if released, I will undermine or jeopardize the objectives of the proper functioning of the criminal procedure of the criminal justice system as envisaged in Section 60, subsection 4, subsection D, read with Section 68 of the Act. I respectfully submit that the following factors are of pertinent importance, namely, I have not supplied false information knowing it to be false at any time during or after my arrest, and do not intend to place any false information before this honourable court by way of this bail application. I am not in custody on any other charge, nor am I on parole pursuant to release following upon any conviction and imprisonment. I have not previously failed to comply with any bail conditions, and I submit that there is no indication that I will not comply with any bail conditions herein. Whether there are exceptional circumstances causing a likelihood that my release will disturb the public order or undermine public peace, security as envisaged in Section 60, subsection 4, subsection E, read with Section 60, subsection 8A of Act 51 of 1977. I respectfully submit that the following factors are of importance, namely, the onus rests upon the state to prove exceptional circumstances before Section 60, subsection 4, subsection E becomes applicable. I do have a wish to state, I do not believe that my release would cause shock or outrage in any community. It is the very same community and activists who have been standing by my family and I since the death of my son, Jaden Lee. I am deeply saddened to see and hear from my family and attorney that the very same people who stood by me have now turned against me for their own personal gain on social media platforms. I respectfully pray that this honourable court should weigh up my freedom and my ability to prepare for trial outside of the confines of prison as against those aspects. My safety would not be jeopardized by my release, as I would be in the environment of my extended family at my father's home in KZN, as well as within the community where I am unknown. I respectfully submit that my release will not undermine or jeopardize the confidence of the criminal justice system. What truly concerns citizens is for a proper, unbiased, transparent, and professional investigation procedure, and likewise a proper, transparent, and speedy trial process. That does not simply entail the incarceration or detention of an accused person. There is no reason to believe that I would jeopardize the public safety in general. The other factors as envisaged in Section 60, subsection 9 of Act 51 of 1977. I respectfully submit that the Honourable Court ought to decide in weighing up the interests of justice against the right to be released. That is, my right to personal freedom and the prejudice I am likely to suffer by taking into account the following as envisaged in the Act, namely, if I am not released, I would probably be in custody for a very long period prior to the matter going to trial. I have been informed and verily believe that the court rolls of the Regional Court and the High Court are booked long in advance. I am informed by my legal representatives that it is likely that this matter may be transferred to the High Court. However, in my favor, it ought then to be taken into account that it is of the utmost importance to be able to prepare in the matter. If I am kept in custody, I would have unsurmountable difficulties to prepare for trial. I submit that it is also extremely difficult for me to prepare for my trial whilst being incarcerated, in that there are limited times in which to consult with my legal representatives, which have to be arranged with the prison authorities. There is no recording devices, time-saving devices allowed at these consults. The number of my legal representatives capable of consulting with me are limited. Should I be further incarcerated, the financial prejudice that my family and I will suffer is huge. I also stand the risk of losing my job and will be unable to afford proper legal representation. In the premises, I respectfully submit that if all the factors dealt with in Section 60 of the Criminal Procedure Act are taken into account, it is in fact in the interest of justice to release me on bail. I am informed and verily believe that I have to record in particular the terms of Section 60(11)(b), the following, namely, I have never been convicted previously. There are no charges pending against me apart from the charges. I have not been released on bail or parole in respect of any of the charges. I have no interdicts against me or for domestic violence or harassment. In the circumstances, I respectfully submit that there are indeed personal circumstances existing on the facts and circumstances of my personal circumstances placed before this Honourable Court, which the interests of justice permit my release. If released on bail, I undertake to deposit to the clerk of the court a sum of money determined by the court, to comply with whatever conditions this Honourable Court deems necessary to be imposed upon me when released on bail, not to communicate with, whether directly or indirectly, any person or persons listed or specified by this Honourable Court, to stand my trial and to attend punctually to any or all trial dates until finalization of the trial, the granting of bail. I have been appraised of the provisions of Section 60, subsection 4 of the Criminal Procedure Act 51 of 1977. The established approach to a bail application where the accused bears the onus in terms of Section 60(11)(b) of the CPA is that if the applicant satisfies the requirements of Section 64 on a balance of probabilities, he or she will be successfully discharged the onus. The applicant is not required to prove facts over and beyond or generically different from those enumerated in Section 64. The provisions of Section 64 have accordingly become the definitive interest of justice test. It is further important to note that each of the requirements of Section 64 require at least the likelihood of the consequence in question occurring. Anything less than such likelihood will be insufficient to deny bail. I will demonstrate this Honourable Court with reference to each of the provisions of Section 64 that I have satisfied all of the requirements. In considering bail, this Honourable Court must be satisfied that I am not a flight risk and I will not evade my trial. I have been receiving trauma counselling from Bishop Paul Ferron, hereinafter referred to as the Bishop of the Methodist Church of South Africa, which is based in the Lone Hill branch. On or about the 30th of May, Bishop Paul telephonically contacted Major General Kakana, hereinafter referred to as Kakana, during my first therapy session and informed Kakana that the bishop's mobile phone was on speaker and that I could hear the conversation between them. The bishop inquired as to the status of the investigation, and Kakana informed the bishop that it is at the advanced stage and that my close family and I were amongst the chief suspects. Kakana also stated that my family and I were in for a shock, as the investigation is similar to that of the Jocelyn Smith murder, which would imply that my boyfriend and I were the main suspects in their investigations. Kindly find enclosed a letter from the bishop annexed Annexure D. Your Worship, leave the court. May I have leave to read this letter into the record? As the court reads. This is a letter from Bishop Paul Barron. It's from the Methodist Church of South Africa, dated the 30th of July 2025, to whom it may concern. Tiffany Nicole Meek was referred to me, a pastoral counselor, after the death of her son. My first appointment with her was on the 30th of May 2025, and during my discussion with her, the cause of her son's death raised itself. She was having difficulty in procuring the post-mortem report from the police, and I offered in her presence to phone Major General Kakana, a commissioner of the South African Police Services. In this first session with her, I phoned the general and informed him that my phone was on speaker so that the mother of the child could hear his guidance. He made it clear to me that the police investigation was well advanced, and as usual in these cases, the nearest relatives are amongst the chief suspects. He was expecting an arrest to be made shortly. Despite this information, I have continued to see Tiffany on a weekly basis when she was able to do so, and at no point has she indicated that she wanted to run away or hide. She has also continued, as far as I know, to attend her workplace. As can be imagined, within the confines of confidentiality, our major work has been around her very substantial grief. She has not avoided struggling with the massive loss of 2 children and has been unafraid and congruent in her struggle for a meaning in life. If there are any further information in this regard, I can be contacted. It's paulbaron@gmail.com. Thank you, Your Worship. It is evident that as far back as 30th May 2025, I was aware that I was a suspect in this matter, and I did not attempt to flee or evade being arrested. On or about the 2nd of June 2025, my attorney contacted Detective Sergeant Deco to meet and discuss this matter. My attorney was advised that Lieutenant Colonel Sia King was on leave and was due to return to work on the 18th of June 2025, and only then can a meeting be arranged. On or about the 19th of June 2025, my attorney of record met with Lieutenant Colonel Sia King and Detective Sergeant Deco, who informed them that all of the communications updates should be directed to my attorneys, as there were various social media activists and bloggers who were trying to ascertain information from the police with regards to this matter. My attorney also informed both the officers that should I or any of my family members be required to make a statement or be needed for questioning, he would gladly accompany us to the station to assist in their investigations. This was never done, and my attorney was never contacted. Neither was I afforded an opportunity to contact my attorney after my arrest. This proves that I was willing to cooperate with the police and voluntarily hand over myself if I was required to do so. My attorney even addressed a letter to the Provincial Commissioner on the 11th of June 2025, an email saying, see Annexure E attached here too. Your Worship, this is a letter dated the 11th of June 2025. It's addressed to Lieutenant General T. Tombeni, the Provincial Commissioner. It was sent via email. We act for the immediate family of Jaden Lee Meek, duly instructed by his mother, Tiffany Nicole Meek, hereinafter referred to as our clients. We confirm that we have been instructed to assist the family in communicating with the investigating officer and members of the SAPS who are involved in the investigation of the death or murder of Jaden Lee. We have further been advised by our clients that they wish for the members of SAPS to only communicate with our officers, as many social media influencers have been attempting to elicit information relating to the investigation for their own personal benefit and publicity ratings. Please note that our clients have not consented to social media posts and have in no way posted any information on social media with regards to the ongoing investigations. The thoughts and comments of the social media influencers have not emanated from our clients. We have no intention of undermining the state's investigation, the competence of your highly trained and intelligent detectives, and or the criminal justice system. The writer has also telephonically spoken to Lieutenant Colonel Sia King, who advised that he is on leave until the 18th of June 2025, and we are hoping to meet with him during the course of next week to discuss the matter. We hope that both our officers can work together in bringing the perpetrators to justice, and the family can finally get the closure that they deserve and long for. Kindly do not hesitate to contact the writer should you have any further queries. Thank you, Asha. May I continue? My boyfriend, Riaduddin Boysons, from his home and took him to the police station, where we were not sure whether he was placed under arrest, but the police took a swab sample of his saliva and later released him. On the 4th of July 2025, both Riaduddin and Leandro Meek, Jaden's biological father, was taken to Pretoria Cybercrimes Department to have the contents of their phones downloaded. To date, Riaduddin's mobile phone has not been returned to him. It is evident that the state is trying to make this case out to be like the Jocelyn Smith matter and are trying to implicate me and the people closest to me. All of these arrests and interrogations After all of these arrests and interrogations, I still continued to live with my mother and never attempted to flee the police. I was arrested at my mother's place of residence and did not resist arrest. I was visited by my family at prison, and I was informed after my arrest that I have already been tried, found guilty, and sentenced by social media subscribers without them even having knowledge of the state's case. There was also a so-called private investigator who was trying to make me out to be an abusive mother and publicly announced that Jaden's school had complained about a history of abuse. I never abused my child. See Annex F, Annex Year 2, which is an IOL article rebutting these allegations. Your Worship, Annex F has been printed. It is an IOL article which was published on the 16th of June 2025. There is a headline which reads, Royal College denies knowledge of abuse experienced by Jaden Lee Meek. It is an article by Sia Bonga Sitole. It says, Royal College in Florida has denied knowing about the alleged abuse, physical abuse and hunger faced by the deceased 11-year-old grade 6 learner following reports of alleged abuse. A school official who do not want to be named denied reported claims of abuse and neglect of Jaden Lee, who was recently described by her teachers as it says he, but he should have read, described by his teachers as an intelligent young man who made their work easy in class. Please note that this matter is being dealt with by the Department of Education, which will release a statement on the matter. The department visited the school and spoke to our principal. However, those allegations that were made saying that the school was aware of physical abuse and came to school hungry are not true. None of us are aware of the abuse. He never looked like he was abused, and neither did he come to school hungry and with bruises. So we do not even know where this information is coming from, the official stated. I respectfully submit that I have discharged the onus of proving to this honorable court that it is in the interest of justice that I be released on bail. I respectfully submit that in the event of any particular objection is made known to my legal representatives by the state, I will depose to a supplementary affidavit if so need be. Your Worship, the affidavit has been signed and commissioned. Your Worship, may I have leave to hand Seva?
Mr. Meek, do you confirm the truth and the correctness of this affidavit in support of your application and that you have signed the acknowledgement thereof? Thank you. The affidavit is so received, mark Exhibit A for the record.
As the Your Worship. Your Worship, that is the applicant's case.
That's the applicant's case.
Thank you. Your Worship, we are then recording case SH 233-2023. Your Worship, the state's request is for the matter to Worship to be rolled over to Monday, as it is known, or rather, the matter was scheduled. The date was arranged by your sister in court, Your Worship, on Monday, with the view that she will proceed with the application. Unfortunately, due to the circumstances, Your Worship, the matter was midweek. The matter was then allocated to this court, and whereas we had already booked another part head with a child witness whose evidence we really need to take, Your Worship. So at least we have accommodated the accused as far as possible. So our request, Your Worship, is that we proceed with the state's case on Monday morning, the 21st of July. I have addressed my colleague, Your Worship, yes, about the development.
Yes, thank you, Mr.
Thank you, Your Worship. Your Worship, unfortunately, we were not made aware that the state intended only leading the applicant's evidence and then asking for a remand prior to us leading our evidence in the matter. We were of the opinion that the matter was going to start and be finalized today and possibly be adjourned for closing arguments. Your Worship, we're in an uncomfortable and difficult situation now in that the state was given the applicant's unsigned affidavit as early as 9 a.m. this morning in the hope that they could prepare the investigating officer for any possible cross-examination. It now seems that the accused is being prejudiced in that the state is asking for a remand so that they can prep their witness after the applicant's affidavit has been handed in. Your Worship, the state suffers no prejudice if the investigating officer was to lead his evidence at this stage, and we can reserve cross-examination until Monday. So
That would have been desirable under the circumstances given the nature of the bail application being taken. But you must remember that this bail application was not set down to commence in my court today. However, it had to commence in Court J. There's a child witness who has been here. I think this is the 4th time. That is correct. There's the advocate. She's flown in from Cape Town to assist in finalizing this matter where her client has been in custody. How long, ma'am? Her client has been in custody more than 3 years. It's a juggling act that the court has to do. Absolutely. The court have granted the indulgence for the matter at least to commence. If evidence and addresses is wrapped up Monday morning, then by Tuesday morning judgment will be delivered. That I can guarantee you. Thank you. Thank you. Thank you, sir.
To address this, because we are officers of the court, and our integrity also must be respected and preserved. I mean, I accept my colleague's indignation about the request for a postponement, but to insinuate that it's a ploy on behalf of the state to go and prep our witness, it doesn't sound right, and I'm requesting that my colleague retracts that, Your Worship. I will really take exception to that.
Thank you. This is noted for the record. Under the circumstances, Mr. Naidu, can we accept that this is the directive of the court, that the matter cannot proceed under the circumstances?
they accept that, Your Worship.
Thank you.
No disrespect to my colleague, but it would seem that under the circumstances we were not informed that they will not be able to accommodate or make the matter partly heard this morning. If that was the case, Your Worship, we would have considered to the matter being remanded from the outset. So it's difficult that my colleague didn't play open card and advise me of the court role, where I would have not proceeded and made the matter partly heard. We could have started.
The court would have insisted that the matter.
Your Worship, that was.
Monday comes with its own set of problems.
I totally understand, Your Worship,
So
but
at least for us, we have utilized time that was given to us at this juncture.
I appreciate
Let's
that, Your Worship.
continue on Monday, and hopefully we can finalize the matter by Tuesday morning.
As the court pleases, Your
Thank
Worship.
you.
Thank you, ma'am.
Thank you. The matter is therefore rolled over till Monday morning, where we will continue with the state's case. I have placed on record the reasons why at this juncture we cannot proceed, because we need to deal with the evidence of a very, very young child. It's 12 o'clock in the day, and the possibility is there that
at 1 o'clock or 2 o'clock or 3 o'clock, the child might be tired. Like I indicated, this is not the first time this child is here. As so directed, matter now being postponed until Monday morning. For continuation, you are in custody. Thank you.